Well, good morning and afternoon, everybody. For those of you on the West Coast and throughout the Midwest and here on the East, this is the 8th in the series of C-SPAN CARES Act webinars. Today we'll be having a comprehensive review and update on where things stands with the CARES Act, and as importantly, if not more so, what I'm very much looking forward to is the opportunity to hear from 4 noted attorneys within our community who will be sharing some of their perspectives, not their official positions, but their perspectives on a lot of things that are important to our community. I'll get started as we always do in about 10 minutes, at 5 minutes before the hour, and then at the top of the hour, I'll remind you of a couple of the do's and don'ts and some of the things that you have at your disposal to help with Q&A, and we'll get started in about 10 minutes. So welcome those of you who have started to join. Still no luck, Chris?
No.
That's weird. I don't know what's...
Says I need to go to system preferences to add it, but
I like you closer in, Jonathan, by the way. Thank you.
go to meeting is not an option for the camera.
Oh, did I do something? I didn't realize I changed my video.
Well, yeah, you did. You panned out a little bit and then panned back in. I like the pan in. Stay where you are.
Okay. Yep.
Just so you're aware, before we get started, 345 people and growing registered. So we normally get around a 70 to 80% return from those that registered. Obviously, things come up and people don't all make it on, but so pretty good crowd for you all today. We normally average right around that, around 245 to 300. Early on, we had one over 400.
Dennis just sent an email. I don't know if you saw it, but he doesn't seem to have a personal. I think he missed the email maybe from Jerry on how to get in as a presenter.
I'll respond to him. I will also send him mine. Hopefully that can help, if nothing else. We have about 5 minutes before the top of the hour. Once again, welcome all of you who have joined in for today's C-SPAN's CARES Act webinar, a comprehensive review of the status and updates with regard to the CARES Act on all 3 levels, both policy planning and, the Paycheck Protection Act program, as well as the information on the HERF funds, and last but certainly not least, the higher education policy guidance that we're awaiting. As I said 5 minutes ago, the other half of today, or more than half of today's presentation, is going to be attorney's perspective. We have 4 noted attorneys from within our community joining us today, who I'll introduce here shortly. I'm very much looking forward to hearing their thoughts and their perspectives, as I'm sure you are as well. A couple of disclaimers that we'll go through at the beginning. This is a conversation, not an official dialogue on their perspectives, but basically a more generalized conversation. We'll get into the official disclaimers here in just a few minutes, but welcome as all of you join, and as we prepare to present today to you on the latest 8th of the CARES Act webinars by C-SPAN.
Hey guys, can you hear me?
Who just joined in?
It's Dennis, Tom. So I just signed out of the webinar. So now I'm going to try and get on, use the phone
Okay.
audio.
Audio is coming in loud and clear. Hopefully we can get you on the video as well.
But yeah, if I can, I'd like to.
No worries.
This is ridiculous.
All right. My webcam.
There you are.
Hey, there he is.
Waiting on Chris and Aaron.
I'm here on audio. I can't get the webcam to work.
Okay.
All right. All right. You all get to see my bookcases that I developed just for COVID, because no one ever wanted to do a video conference with me before, but now I had to build some bookcases. So there we go.
Well, there you go.
Yeah, I had to reorganize my books so the more impressive ones show up in the camera view than the junk fiction.
Exactly. We all see the law books, the different colors. Yes.
Exactly.
Why we all go to law school, to get books for impressive libraries. So
and it's probably about $10,000 worth of books from law school.
you know. The laws are all
See, and now you're getting a little bit of insights into the backside before we start a presentation.
Yeah, I was going to say, the audience is appreciating this, I'm sure.
See, Chris, maybe it's good that you don't have the camera, because we don't know what your desk and what your books are on the bookshelf. You can obviously see what I care about. There's the Capitol in the background, and I don't know if you can tell, but literally the painting that's done in my study is an exact replica of the paint job that was in and is currently no longer in the House Education and Labor Committee, Education, the Workforce Education and Labor hearing room. Spent a lot of time there. Capitol's my place, so that's what we painted it when I got the opportunity to put my office together.
Yeah, very cool.
very cool.
Well, we've got just a few more minutes before we'll get started. We're hoping for Aaron Lacey to arrive here in just a few minutes. Again, we have over 200 attendees in of the 350 or so that are registered. So we're going to give another minute or two, because a lot of people come in right at the top of the hour. We'll then provide a couple of the obligatory do's and don'ts and other disclaimers before we get started. But as I've said several times before, we are very much looking forward to today's 8th in the series of CARES Act webinars, where we will be sharing a comprehensive update on the latest information that is available from various aspects of the community in terms of the CARES Act, whether it be the Paycheck Protection Program, the HERF, or policy guidance, and the ability to have a conversation with 4 noted attorneys in our community. So I'm very much looking forward to that, and have 3 of them on the line, and hopefully Aaron will be joining with us momentarily. Give us just a minute or two. I'm going to grab my phone, because I think that's him, and get back to you.
Dennis, are you in the city?
No, thankfully. So I'm in my office is in Manhattan, but my house is in Westfield, New Jersey.
Oh, that's right. You're okay. So you're good.
Yeah, it's not nearly the same risk levels here. I can still walk my dog, go outside. It's not as bad.
Yeah.
Oh.
Okay, well, we're going to go ahead and get started with today's webinar. We have 3 of the 4 attorneys on the line, and hopefully Aaron Lacey will be able to join with us momentarily. We have a few minutes before we actually get to the first round of questions or the discussions with the various attorneys, so hopefully he'll be able to hop on. He might be detained with a client or with department officials, who knows. But we do want to welcome you to today's 8th in a series of C-SPAN CARES Act webinars. Today's focus will be on a comprehensive update of the various facets of the CARES Act, as well as an attorney perspective. One of the things that I do want to make note of, as we always try to do, is the realization that this is basically not full-on counsel information from the standpoint of providing their legal advice, but simply a dialogue and a conversation of information. So this is information only, not an actual legal advice from the various attorneys. We do encourage you, as we always do here at C-SPAN, to seek out your counsel and also your third-party servicers and others that help you with your decision-making process to make determinations, especially in these very challenging times with a great deal of new information and new guidance that needs to be interpreted, planned, and implemented, which hence is a lot of the reason for today's continuation in the series of the CARES Act webinars. What we are going to do today is go through several of the various aspects, but I did want to start out by acknowledging the 4 individuals, 3 on the call now, and the 4th hopefully to be added, of our attorneys who have provided and accepted our opportunity to share time with us today. Dennis Cariello, as you can see, with his new bookshelf. That's right. Shareholder with Hogan, Marin, Babo, and Rose. Chris DeLuca, attorney at law with DeLuca Law, and also of counsel with Rose, Fret, White, Goss, Gentile, and Rhodes. God, that's a mouthful, Chris. Aaron Lacey, a partner with Thompson Coburn, who will be joining us here soon. And also, last but not least, Jonathan Tarnow, who you can see as well with all of his law books behind him, a partner at Fakery, Drinker, Biddle, and Reith. So we want to first start by thanking all of you guys for taking time. And I know it's been a very, very busy time for all of you responding to questions and information, for sharing time with us today. C-SPAN and I very, very much appreciate it. What I hope to go through today in terms of the agenda is a brief, very, very quick overview and turn this into as much of a panel discussion and dialogue as possible. We'll go through, as I said, a brief refresher on the Paycheck Protection Act program and some new guidance that came out 2 days ago from Secretary Manchin and others with regard to the SBA loan process. A lot of discussion on the Higher Education Emergency Relief Fund. We know you have a number of questions. I've taken many of your questions and have them prepared to offer, which brings me to a key point. As we always do, the Q&A function is available for you to utilize in order to bring your questions to today's discussion. All of the discussion today is, as are all C-SPAN videos, being videotaped along with the PowerPoint presentation so that you can review them later at the C-SPAN website and look at those and continue to maybe re-listen to some of the guidance and information that's going to be provided. Again, information, not true advice of counsel. Leave that to your actual counsel as you have discussions with them. Last but certainly not least, a very, very brief discussion, because there's not much there to share at the moment, on the higher education policy guidance side, but I do have some information on when we hopefully might expect to see some of that, and the broad Q&A that goes afterwards, which is where we'll spend the vast majority of our time today. Just a couple of quick slides. There's the CARES Act once again. There's a picture of President Trump signing the second stimulus package of the two portions of the CARES Act. As you all know by now, and as we all have lived through, as we continue to strive to come through the challenges of the COVID pandemic, this is the third and fourth in a series of pieces of legislation that were provided back in March and into April that attempt to not only address health-related concerns and issues, but in the third version included major portions of funding and guidance with regard to higher education policy. It also included in the fourth iteration the update to the CARES Act on the SBA PPP side, additional funding for institutions that are small businesses and others to look towards to potentially help sustain the employment of their employees, the retention of their businesses, and the opportunity to try and keep as much as possible business running as normal. The dates of the original CARES Act once again date back to the end of March, where very, very quickly Congress moved forward with the $2.2 trillion stimulus package and the funds that followed from that. We're going to take just a minute to remind you and refresh you of the Paycheck Protection Program. I do know and am aware that some institutions were able to successfully complete that process both in the first iteration and in the second iteration and receive some of those funds. I do believe that others of you are waiting. Just a real quick reminder, the entities that were eligible to be provided the opportunity to apply for as borrowers for the loans, which could turn into grants, included nonprofit organizations, small businesses, and others. The program was capped at $10 million for sustainable funds to provide, as I said before, payroll for staff, as well as the other cost of running your business. The determinations are made based on payroll and other information and a multiplier effect, with the grants being given out and before being potentially turned into loans, predicated on whether or not you sustain full employment as you had prior to the actual pandemic and what operations look like post pandemic. The period of time to disperse those funds and utilize them are 8 weeks from receipt of the funds. Rehiring will run through the end of June and are based on changes that are made between February and April 26th. Some new guidance: there was an interim final rule and some frequently asked questions put out at the beginning of this month. As I said, the new information that I wanted to share with you before asking the first question of our panelists was just the day before yesterday, Secretary Mnuchin and SBA President or SBA Executive Director Carranza stated that to further ensure that loans are limited to eligible borrowers, the SBA has decided in consultation with the Department of the Treasury to review all loans in excess of $2 million in addition to other loans as appropriate. This shows that we had heard early on that potentially there were entities that have been utilizing or applying for the funds that may or may not have been those that truly Congress and the various agencies were intending the money to flow to. The basis for this was to truly try and get at small business and other operators that were not flush and were having considerable strains in maintaining their operations, not some of the larger entities that had full pockets or deeper pockets that they could rely on their own. So this shows that while Shake Shack and many others have been, Ruth Chris and others have been returning their funds, now the funds have been basically all administered, we're starting to already see immediately following that the assessment and the rationale for oversight and ensuring that the funds are being used with integrity and by entities that they were truly intending for the funds to go to. So I think that this foreshadows things that we will see, but I encourage the attorneys to chime in here in a second of the things that we'll start to see as we get further along down the road with the HERF funds, both on the student as well as on the institutional side. But I'll stop here and see if the attorneys, because I know that a lot of the attorneys played significant roles within their firms, maybe not necessarily them directly, but their firms or maybe them directly with their clients in assistance on the Paycheck Protection Act program. So any of the four of you gentlemen want to just simply share your perspectives on the PPP, what you have experienced on behalf of or with your clients, and again, just general information around this particular portion of the CARES Act?
Well, sure, Tom. I'll start off. I mean, I think there are two things that we have to be mindful of. I mean, in preparing these applications, one thing that all of the folks out there have to remember is if you are owned by a private equity fund, you got to go through another level of analysis because, again, we don't have the full eligibility rules, but small business has got to have no more than 500 employees. However, the SBA has an affiliate rule that says if you're affiliated with another enterprise, you count those employees. And this often precludes private equity-backed institutions from being able to access small business administration loans, this being one of them. So that's something I strongly advise, getting counsel on this point. Again, someone hopefully specifically SBA counsel that can help manage this, because there are some things you can do to divorce yourself from your private equity sponsorship and the control of that to become eligible. But again, it's fairly complicated, and obviously given how much the subscription or oversubscription this loan program, you should do that rather quickly. The other thing I want to point out with the notes that you have here about the $2 million, and I think this is a broader topic that people have to be mindful of throughout all of the CARES Act programs. There are going to be audits. They're going to be checking. So make sure that it's, you feel comfortable taking this money, right? And make sure that you're doing everything right. You're getting it into the right hands. Again, we'll talk about with the HERF grants and, to students. That's a huge issue, making sure that they get the money as opposed to you pocketing the money in some way. That would be real problematic. And I think you see that here. Any loans that are more than $2 million, although it can go up to, I believe it was $10 million, the supposition is $2 million is a lot of money. A lot of small enterprises with 50 or so employees probably only drawing about, in the neighborhood of about $1 million, $1.5 million. And so they're using that as a marker to say, well, you're probably a pretty big enterprise. So we're going to make doubly sure that you do right. So this way they don't have a, kind of political egg on their face, as was the case with Ruth Chris and Shake Shack.
Yeah, and I think there's a lot of practical issues you have to think about too when you're doing this. To Dennis's point, the documentation is going to be very important, and I think we'll talk about this. I assume we'll talk about this when we talk about the use of the Higher Education Emergency Relief Fund grants, but also thinking about how you're using the money. And if you're using paycheck protection funds that are going to get forgiven, then the idea of, then you're also going to be using education funds to maybe pay for your employees when they go through training, the transition to temporary ed, or if they're helping with curriculum and things related to COVID-19. You're not double dipping. And I think that's going to be something that folks are going to be want to be careful as far as how we're documenting.
Anything from you, Jonathan, or from you, Aaron?
Yeah, this is Jonathan. I was just going to add, and I have others in our firm, including a former chief counsel of the SBA, who are really leading our PPP efforts. But I will say that, and we'll talk about, I think, probably later with respect to HERF, the continued payment of employees and contractors under HERF. You all who have applied for the SBA PPP program realize or should know that, similarly in that program, you have to certify in good faith at the time of the loan that you are not going to furlough, fire, lay off, or et cetera, some number of your employees. And there's obviously thresholds, which we won't get into in terms of, maintaining a certain percentage or all of them effectively in order to have the loan forgiven. What my government contracts colleagues are saying is that, look, this is when you're making that certification, which is a certification to the government, you really have to think carefully about that, and we'll get into this with the HERF language. But I think there's a general thought that you shouldn't have to expend all your reserves, drive up your lines of credit, jeopardize the ability to even survive over the next 3 or 4 months. So, you know, your intentions and what your plans are and what your documented intentions are as of today when you're applying for the PPP, I think are really critical. And I think documentation throughout all of these programs, we'll talk about it in HERF, is going to be essential as those audits and investigations inevitably come, you know, later in 2020 and certainly in 21 and 22.
Thank you. Aaron, Aaron Lacey, anything to add? And welcome, thank you. We introduced you as you were coming on board, so welcome for your participation as well. Anything to add?
Yeah, no, I appreciate that, and I'm going to see if I can even get my video here in a couple of minutes. But no, actually, I just agree with everything that's been said. That's one of the advantages of being on a panel with a bunch of smart folks, is that they tend to say good things, and I agree. I think documenting and preparing to be audited, you know, and understanding that anytime the government gives away gajillions of dollars, you can expect that there's going to be a lot of folks trying to figure out where it all went and how it was used. And so wholeheartedly concur with all those feelings around the need to be very careful with how you use this money and to track it and trace it and be ready to document and show how you used it.
I appreciate that. All right, now we're going to get into, I had this slide just because early on, again, we were all looking at this, or at least I thought we were all looking at this from the pieces of the puzzle of how during the pandemic institutions might be looking at ways in which to help try and keep all of the financing for their institution there. So just, you know, another one of my little quirky pictures. Moving on to basically what I think is going to be the lion's share of today's call is the HERF Act, the Higher Education Emergency Relief Funds, and certainly the two facets of money that institutions have the capability to draw down as grants assistance. We at CSPN have provided a number of webinars on the process. I've been involved in a number of those conversations with other state associations and other third-party servicers with trying to help navigate the actual application process, which was not as simplistic or easy as maybe all of us had thought or hoped. We won't spend time talking about that today, but what we will do is continue to remind you that as you need additional guidance or information on the HERF as it relates to the Department of Education, this is one of two websites that I literally visit on a daily basis. The other one we'll share with you later in this presentation to try and track if there's any new guidance or information forthcoming from the department, both in terms of the funding and the finance side, but also overall COVID guidance and direction, again, that we'll talk about later. We are very much aware that the Secretary, over the course of the two previous Tuesdays, has come out with consecutive opportunities for press releases and announcements to the general public, meetings that we've been involved in, myself and others have been involved in with the higher education stakeholders, where they have conversations with the community to discuss their announcements with regard to, in this case, the financing in the first of those 2 weeks ago now, almost 3 weeks ago now, on the institution, on the student side of those finances, and the initial process that they started to discuss on how the funds should be accessed. Then last Tuesday, the conversation on the institutional side of those funds, and some degree of discussion around the guidance of what those funds can or cannot be used for, both from a student perspective as well as from the institutional aid perspective. We're going to go into a much deeper dive of that as we go through the slides and a number of questions that have been posed in prior CSPN webinars and certainly have been kicked around within the community, but that's where we'll start the conversation. We all know that last week, in conjunction with the announcement of access to the institutional funds, that two FAQs came out, one on the student side and one on the institutional side. We're going to start on the student side and then move to the institutional side, both with our questions and the discussion. This is a copy of the FAQ. What also I think is the document that I always sit in front of me whenever I'm trying to assist institutions in at least charting or looking at what information is available for them to read to help them make decisions. This is one of two documents I have sitting in front of me. For the student side, which is now the Emergency Financial Aid Grant Assistance to Students, Grant Aid to Students, I have this document And I also have the actual certification and agreement document that the institutions are required to sign and were required to sign as part of their submission to gain access to the funds. Those two documents provide the most up-to-date and most direct guidance that I think any of us, and I hope the attorneys would agree with me, that we have to date upon which to try and make your determinations and do your assessment of how you as institutions are move forward in order to comply. Again, seeking the resources of your counsel, your third-party entities that may assist you with financial aid and other worthy resources. So those are the two that I use. On the student side in general, some of the things that I think we have learned and can say pretty much unequivocally is that in terms of who is eligible for these funds on the student side, it is students who are Title IV eligible or meet the criteria to be Title IV eligible. That the funds cannot be used for reimbursement for students who were fully enrolled in an online educational program prior to March 13th, 2020. Any individual that on or after March 13th, 2020 transitioned to the hybrid or from a hybrid to a totally online or from totally in institution to online are the individuals that are eligible for these funds. A number of the funds that institutions had hoped could be reimbursed to them from these funds, at least on the student side, we'll talk about the institutional side later, but at least on the student side, cannot be utilized. The funds that are going to the students are just that, going to the students and not to be used for any type of reimbursement, even for disruptions related to the pandemic as a result of the pandemic from the student portion. And that the grant assistance cannot be used to satisfy any of the credit balances of the institution or in other outstanding balances of the individuals. I'm going to stop there once again because that's my 30,000-foot overview and turn to the four attorneys for their initial interpretation and where they think, and if they think I screwed up anything in the fundamental oversight of where things stand before then diving into some more detailed questions on the student side. Who wants to start?
Well, I'll throw out an initial thought, Tom, and I don't know if others think about this way. I actually have started to think about this over the last few weeks as not, and had a conversation or two with some clients. That this is, remember, this is not a hard 50-50 split. There are the two tranches. The department made available through two different grant opportunities. And so there's two tranches of monies coming through. But from an institutional perspective, I think it's really important to think about this as 50 plus and up to 49. And the 50 plus has to go to students and the up to 49 is for institutional purposes. And so how you think about that, I think really influences your documentation, how you're going to, how you're describing it to students. I would caution institutions from saying we're making all of our HERF money for students available to students, because that actually is a little bit misleading. I'd be careful, with that, unless you're doing 100% of your money, because technically all of it's available for students if you choose. So really think about, how you describe this to your community in terms of what dollars, if you're being transparent with the dollars you were allocated, it's 100% allocation, at least half of which you have to treat consistent with the student side, and the rest you can use for institutional purposes. And again, I think the way the department structured it blurs that line a lot. But conceptually, I think that's a really important thing to make sure you always have in the back of your mind.
Yeah, and I think the goal with the student portion, is the department is looking for cash in the hand of students, not necessarily green cash, check, however, but they want money in the hand of students. And, it's something that comes out a number of times in the guidance that they don't want the money being used to cover various institutional charges. I think there are some very limited exceptions, right? If you provided students with a grant out of your own money, right, after the CARES Act had been passed, but before the money had come up, well, then you can reimburse yourself for that. But Other than that, we're really looking for money in the hand of students, and they can make whatever determinations that they want to make on how to spend that, but you have to get it to them, which is causing a difficulty for a number of clients, particularly smaller clients that may cut their own checks. If you're in a place like it is, like here, I'm in New Jersey, and it's actually very difficult to get in the building, literally in the building, to access the printer to cut the checks. And so, there are a number of things you're going to have to do to try to get this money out the door. You have some time to be able to disperse it, but again, I think the other thing the department made clear is, although you have a year to disperse the money, they would really want this money dispersed as soon as humanly possible, so it's being used during the time of the crisis and where people are trying to make ends meet.
Yeah, and I think to Dennis's point there, with the department looking to get the money to the hands of the students as quickly as possible, but also there's a lot of questions about, well, how are you going to do that? And I caution against rushing into just cutting checks to everybody, because you're making sure you've thought through your process, because there's a lot of discretion given to the schools. Do you give everybody money? Do you give everybody some money and then more to students that have more need? How do you calculate need? Because if you're going off of EFCs, that may be based off of 2018 tax returns that have no bearing on where the family or where the student's financial position is in April and May of 2020. So there's a lot of questions and things with that, and recognizing you're going to have to document all this. So whatever you do, you're going to have to, your plan, your documentation as far as how you're going to allocate in your plan for distribution, that's going to go to the department, as well as all the follow-up with, showing that money's went out. Assume your auditors are going to be taking a look at that, and certainly the department may choose to take a look at it. So making sure you've got that plan, and then to Dennis's point, you get into the logistics. Well, how am I going to get the cash to the students? Am I going to cut checks? Can I get to my school? Can I get to my checks to cut them? Am I going to use debit cards? Am I going to use electronic funds transfers? And again, you've got flexibility, but then you also have to recognize if you're going to work with your bank or I've heard of one school working with their payroll processor to issue debit cards to students. So that's great, but recognize that if you're issuing a debit card to a student for $500, that student has $500, that there's no fees in there, that they're not going to be incurring 3% a month on unpaid balances or anything. They have to have if it's $500 is their grant, that they're getting that. Any fees or your costs associated with that can't come out of that student funds.
Aaron?
Yeah, I mean, I guess from my perspective, one of the things I've been chatting with clients about, and I tend to favor, is keeping things as simple as possible. The secretary says repeatedly, I don't think there's any contest or anyone who contends that, institutions don't have ultimate discretion. They do have ultimate discretion, and that's made clear within just a small number of parameters. The very first day that meaningful conversations around these emergency grants started, I had a client who called and they had a really elaborate and complex scheme that they had come up with. It involved multiple tranches, and they were going to disperse over, several weeks and months. And there was a lot of merit to what they had to say. They were trying very hard to assess the need of individual students. I agree with prior comments, whether Pell Grant eligibility or EFC is really a measure of current need. I think that's doubtful. But I also think it's going to be extremely hard for institutions to determine real need or to make distinctions, that are meaningful between even a group of students and another group. And I think the more you get into the weeds and more complex your system becomes, the greater the likelihood that you're going to introduce human error, that you're not going to be consistent in how you administer it, that you might inadvertently walk into some sort of discrimination claim. So I've been encouraging a lot of my clients, understanding, again, that complex systems, trying to get at student need are all worthy goals if or can be worthy. I still think that keeping it simple makes a lot of sense. It's going to make it much easier to track, to administer consistently. It reduces the likelihood of student error, et cetera. And the secretary has indicated in her letter and elsewhere that, schools have the discretion to give everyone the same level grant or to look out there and try to group students into just a handful of groups. but to keep things relatively simple. So I like that idea. I know I'm beating the dead horse, but I think in this case, it is a dead horse worth beating.
Hey, Tom, can I just add a thought to that, or I don't know if we're going to cover it, but I think another, I agree with everything was said about, trying to keep things simple, with the caveat that the department made very clear in this guidance that you could use these funds for future academic terms, for emergency aid in future academic terms, if, again, it still has to relate back to disruption of the student's educational experience or other expenses they've incurred. And I've had several, depending on the nature of your allocation, if it's a larger allocation, if you have longer term programs, you might have some students who don't have the same need today as other students, but maybe in 3 or 4 months, depending on what happens with the economy, their spouse or their somebody in their family loses their job and their household income dramatically changes. So there are a number of institutions. Again, this tends to be larger institutions with larger allocations that I've talked with over the last couple of weeks, who are, reserving some of the funds. There's definitely a desire to get it out quickly, but reserving some of the funds because there will be some pockets of students who don't have a present need, particularly students in longer term programs. Maybe they had a break. This is certainly true of traditional academic institutions with the semester just ending and now a summer break. Their need might not arise until the fall, depending on what happens with the economy and their personal circumstances. So some institutions, like to beat a dead horse, to use Aaron's phrase, some institutions with larger allocations, with longer programs, are reserving some of the funds back for that contingency. Again, the students will have to demonstrate whatever additional need in the fall and next spring still relates back to disruption in their program. The risk of that from the institution's perspective is if you don't expend those funds within the year time frame, you lose them. So you have to balance, I think, that consideration if you're in that situation.
A series of questions that. Go ahead. Who was that?
No, it's Dennis. I mean, I agree with that. I think that's something I've recommended as well, reserving some portion. And I think the one amendment I'd have to what Aaron said, because there is a lot of value in a fairly simple measure that everybody gets a set amount. What I've suggested folks do is use this process because you're going to have to communicate with students. You've got to communicate the instructions and how they're supposed to spend this. And hopefully you're getting forms signed and certifications that they're going to spend the money the right way. But you can also use this process when you're giving out money of soliciting extraordinary need. And I think that would be a nice way of tailoring things if there are people that are facing really extraordinary circumstances. And also, if you're holding that money back for what is inevitably going to happen. Someone's computer is going to break in August, right? And you want to be there to be able to provide money at that time so the way they can continue their education, just as Jonathan said. So that would be the one thing I think about. I like the idea of reserving some money to cover those, extraordinary needs or those needs that don't necessarily manifest themselves at the present.
A couple of the normal questions, I say normal, nothing's normal. Some of the routine questions that I'm looking for affirmation from you all. Would you all hopefully agree, as has been provided in terms of guidance as well by the CPA firms, that developing separate ways to track this money, and maybe going as far as separate accounts or separate designations within your accounting processes for each of these forms of funding is a smart move?
Absolutely.
Yeah.
I thought so. I just wanted to get the affirmation.
I would say separate accounts. I mean, you should be able to work with your bank to set up a separate bank account. That shouldn't be very difficult in that way. You don't want there to be any allegation that you're commingling these funds with your operating funds.
Yeah,
I am hearing
Chris is a CPA, but I was going to say separate accounts. I would, if you can code it differently in terms of your financial coding as to where the accounts are being applied to student or how the checks are being cut, and I mean all of the ways you can have an independent, distinct audit trail for these monies is absolutely critical.
Chris, I have heard from some institutions that banks are simply not opening up new accounts, which is the only reason that I asked and said maybe designations within existing accounts. But the ability to clearly delineate, I think, is something that everybody agrees with. And I just wanted to reaffirm that. A couple of other questions that routinely come up with regard to this. Ed is stating that the students who are eligible for Title IV are the ones eligible for relief, but what about the students who didn't complete the FAFSA? They're eligible under Section 484, but they don't have a FAFSA. What do you recommend institutions do? A, would you agree that those students are eligible? And B, what would you recommend in general for institutions to do to be able to substantiate that they meet those Section 484 of the Higher Education Act requirements?
This is Aaron. I'll jump out on this one. And I think this actually ties to the prior conversation about potentially holding back funds. I mean, there are several, question marks right now. I know there's considerable pushback from all of higher ed around the determinations on, undocumented students and non-immigrants. Not all, but there is pushback. There are people trying to get the department to rethink that. And then you've got this, lack of clarity around students who may be cash-based students who've never actually applied for Title IV or filled out a FAFSA. And, when we talk about holding back funds, I mean, I think this is a great reason, among others, the ones that have been articulated already, for potentially holding back a bit of money, right? So, for example, you could, when you run your numbers, you could include all of these students that you think are potentially eligible. Let's set undocumented and non-immigrant to the side. But let's say you're going to include a group of students you think are Title IV eligible, but you're not certain. And, you could get a self-certification or something like that. But if you want to take a more conservative approach, you include them, but you hold back those funds pending further guidance from the department or, an effort to get them to actually fill out a FAFSA or something along those lines. And then if you wanted to distribute that money at a later date, once you had a greater level of certainty around that particular, their eligibility or whatever the issue is, you could do that. The other point I want to make is just, I think not only do you have reasons that are sensible, again, in this sort of overall trying to keep it simple, but there are very good reasons potentially to hold back some funds, no doubt. I think the other thing institutions have to be prepared for is the idea that students won't cash checks. You're going to have at least some students who have just disappeared, and you thought they were eligible and you prepared to cut them a check and they never claim it. And I would make sure when you are coming up with the protocols for your program that you have some sort of provision, whether it's the life of the check, 60, 90 days or something like that, so that you're keeping an eye on the money that doesn't get claimed, and you notify students, particularly potential recipients, that, if you don't cash the check within so many days, we reserve the right to redistribute it to other students in need. But you should certainly think through some of those scenarios, and I think I would articulate in my internal protocols how you plan to manage those and also inform your constituency.
Thank you for that. Again, another one of the fundamentals. Would you not all agree, even though schools are now starting to receive their funds, that it was prudent, and hopefully they have taken the steps to develop their policies and procedures, have posted those and published them and walk students through them and have them available so that everybody can see what the process is and you can utilize that to verify the reporting on the back end? Is that what you've been counseling your individual clients to do?
To the extent that they can. I think developing the process and procedures is important, and communicating that to students is equally important. It's actually required. You're supposed to give the students instructions. I think as far as making them, I wouldn't necessarily put on my website or something, but I think that that's something that you should try to do. I fully admit, though, it's, if you send out an email to the students, there's not necessarily guaranteed that they're going to read that email. And I don't know that during this time schools have the resources to pick up the phone and call each student and walk them through. I think that's a great circumstance if you do. But a lot of the smaller schools that are having their own problems staffing things, that becomes a challenge. So I think that's something you should, if you can do, I think that's great, but you should communicate it in some form or fashion. And if you have multiple forms, I would do so. Send them if you send an email and then send a text saying, hey, we sent you an email, please check your box. It's really important. You can get some money to cover some of the expenses. I think it'd be useful. And one thing on the FAFSA question, what I've counseled people is, if you can, try to get them to file the FAFSA. Right. This way, you're not making a determination on your own. Right. This is, now it's saying, okay, you are eligible, because you were able to file that FAFSA. And but if you can't get that done or students are unwilling for some reason, then perhaps you, if you want to venture into making your own determinations and getting the information yourself, you could certainly try. But again, you take some risk with regard to that. If you do that, though, I would certainly have in any certification that the students have to sign that they are testing, that are going to use the money properly. I think I would also put in there that they are testing that they are eligible for these funds, and kind of list the factors of eligibility, not as a complete coverage for doing it on your own or not doing it properly on your own, but at least just another thing that you say, look, the student said so. We engaged in an inquiry. They didn't want to file FAFSA. We thought they were eligible.
If I can pick up on that, Tom, sure. I think unless Dennis or Chris or Aaron disagree, I agree. I think if you can get a FAFSA file, that is the only surefire way to know that the student is 100% eligible. I would just say if you can't do that, or it's infeasible to do that, and you follow the course that Dennis just outlined and others, and I think that's appropriate in some circumstances. I think it's also important to check the NSLDS history, because a student who was defaulted in a prior year, who may have been a cash pay student at your institution for reasons of that default, would not be something that you probably would have on. You could put it on your certification, say I'm not defaulted, but between the certification of key eligibility criteria and checking NSLDS for any default history, that would give you, again, a fairly good picture of whether the student is eligible or not. But a FAFSA is the only absolutely certain way to go. I would also say, just on communicating to students, tying back a little bit to what we talked about before, if you have the capability to do an electronic fund transfer, and you've done that in the past with respect to your student stipend checks and whatever, I would not ask the student to re-provide that information. Just have a box saying that to the extent I'm going to receive this, you want to receive it by EFT, you can use my previously designated account, and that just makes things a lot easier on both ends.
An important follow-up question for schools that are starting to do their first disbursements of the students' funds as part of the emergency financial aid, the financial grant assistance to students, and the certification that the school signed off on. It says specifically in there that there's a 30 and a 45-day reporting window, and it talks about the fact that that guidance will be forthcoming from the department. Have any of you heard or have any idea what schools should be looking to do to prepare for that 30 and 45-day window of reporting that is in the certification that they signed, and what is their responsibility if the guidance doesn't come from the department?
Well, on our website, we came out with a form that we think people can use that will track the information the department requests, the amount that was dispersed, to whom it was dispersed, dates, and so forth.
Which is all the statute actually requires. That's all it says that is needed to be reported, is the overall numbers and the amount and who it went to.
So, but if the department, look, the department's going to publish a form. I'm not all that worried about that. If the department doesn't publish a form in, we'll say, a timely manner, because they're just dealing with so many different things, which is true. I mean, they've got a lot going on, and look, I think they should be commended for the speed with which they're acting. When I was in the department, not only do with a CASLA, but also ARRA, and the time it took to get those programs stood up was much longer than what they're doing. So they're doing a great job. But I think they're going to get the forms out there. But if they don't, when they publish it, they're going to say, hey, look, we're going to extend. I mean, I'm not too worried about people having to put ramshackle forms together and send them in.
I agree, Dennis. It is part of the certification, and that 30 days could be up pretty quick with schools that are starting to put forth those funds right now that are needed by the students that everybody wants. And I completely agree the department has done a phenomenal job of what they've done in terms of getting out the guidance they have thus far. And as we'll talk about a little later in this conversation, much, much more to come in the not too distant future from what I'm hearing. But that was just, I know that there's those ties to the 30 and 45 days. And right now, that's another one of those open-ended areas.
I mean, I would agree with
Hey,
Dennis.
Tom.
I mean, I think, I was going to say, I'm not too concerned the department won't meet it. I mean, it's incredible. And again, I don't think any of us would generally sit here and laud the department on a given day in a uniform fashion. But given the staff reductions that have occurred over the last 3 or 4 years, the amount of work that's occurring at the department and the responsiveness, I think, is actually pretty remarkable. One thing they had to do under the Act was within 30 days of the CARES Act, they had to issue not just on HERF, but they had to issue forms for the governor's fund. They had to issue applications and forms for the elementary and secondary fund, the discretionary grant fund. They got all that done within the 30 days. They now have all of that work done. So I do think they're now going to be turning toward these more administrative aspects. Now that the monies are all at least available to flow, if not flowing,
Right.
They'll now be turning to those other things. And I'd be surprised if we're caught flat-footed when the 30-day mark comes along.
Well, I think some of the ones that are asking is they're trying to get an early indication of what they might be preparing for. And I think that several of you have already answered it. And I'm glad that I echoed what you all have said, which is, look, guys, what the statute, if reading a literal interpretation of the statute, what it says you're responsible for in the reporting under 18004, I think it's 6, is the ability to simply tell who received the money and how much overall was awarded to whom. So and
the methodology for how you made those decisions. Going
correct.
Back to our earlier conversation about whatever your plan is as an institution, make sure you've documented it. Make sure you've documented it internally and in the communications to students as to how you're making these decisions about who gets what.
Aaron, I heard
Tom,
you chime in.
Yeah, and I just want to a couple of points. I mean, one is I think it's worthwhile to draw a distinction between, this immediate reporting obligation, and again, I mean, when and exactly how it's going to come to fruition and what has to be provided. That's one thing, but that's in my mind a little distinct from sort of, and I want to make schools are thinking this way too, make sure they are, that's a little distinct from what you really ought to be thinking about in terms of the records you ought to be keeping, right? So it's one thing that right now that there's this obligation says, well, these are the 3 things we want you to, potentially report. But if down the line there's an audit or something like that, I mean, they may ask for a much broader range of documentation. They may want to get into the weeds far beyond what you are obligated to actually, sort of report outside of an audit, right? Just under this obligation. And I know everybody has said this, but it's really critical. I mean, you need to create, if you're a school, you need to have a physical or electronic place where you are maintaining all of the records related to your administration of this program. So, as others have said, we're talking about the protocols for distribution. We're talking about individual certification forms that students might sign. One of the parameters here is that you try to maintain your workforce to the maximum extent possible. If you're engaging in workforce reductions, you may need to include in this same place where you're keeping all these other records, your memo to file or explanation as to why those workforce reductions nonetheless were made while you were still complying with that, as much as practicable requirement. But I just want to highlight, that there's this obligation to report. And they say, oh, you got to report these 2 or 3 things. And I agree, there'll probably be a form and we'll do that. But that doesn't mean, if the Democrats take the White House in November and the Senate, that a year from now or 2 years from now, you won't have a much more robust audit as to how you used all these funds. And I just want to be really clear that even if this reporting obligation is a little bit on the lightweight side, everyone needs to be documenting to the teeth.
I completely agree. I'm going to transition now. I've monitored the time. We're going to transition now over to the institutional side, the institutional FAQ and the institutional portion. Again, the department has shared more recently, last Tuesday, a week and a half ago, information regarding the institutional portion of the overall funds under CARES. And again, that 49 to 50%, as Jonathan talked about, that is available for a number of the issues related to the institutional side. And one of the things that I've always pointed for individual institutions to look at is there's 2 pieces of language that are slightly different. When they talk about the student financing, they talk about the funds are provided for the costs allowed for the significant disruption of the operations of the program in the institution, and that's what the student should have the ability to utilize their funds for. On the institutional side, they talk about for purposes of cost to allow for disruptions in the delivery of instruction. So modification there, but I think words matter in this particular regard. Once again, a quick oversight. The institutions must first execute their request for the student side before being able to execute and request their funds for the institutional side. Most schools haven't had a problem with that. The problem they've had is slowly matriculating through what's necessary to successfully complete the applications. But I believe that with time and a great deal of, again, while we commend the department, we probably would be remiss if we didn't commend our community for their efforts in trying to go through all of these new processes, and especially that application process, and make it through the SAMS process, the CAGE process, the eBiz process, and then the GANS process once you actually get your grantee letter. All of that we've shared and walked step by step through in both C-SPEN webinars, and I've done it with various other groups as well. But once you complete that the first time for the students, then and only then can you submit it for the institution. The bottom line is, and one of the questions that I can answer is, yes, it is the same process. The only major difference is that the certification, the prior certification, is the emergency financial grant assistance to students. The second is the institutional portion. Those are basically the only differences. One of the key things that has been put forward in the FAQs is one of the questions that our community had, because it's self-serving, it only unfortunately applies to our community, is the fact that the funds paid directly to the institution, and that should be institution, not instruction, by the department through HERF will not be included as revenue for purposes of 9010. It talks about what the institution can utilize those funds for, including reimbursement for room and board, tuition and fees, the laptops and other information, other forms of technology that were purchased, caveat, on or after March 13th, 2020. And then also for this regards to those coverage of different disruptions as a result of it. Again, I think some of that, and I hope that the attorneys will share, is things that you're going to need to have funding for, potentially looking for when you come back, as well as the things that you're currently had to spend money on, i.e. masks, sanitizer, and other things for once we start to transition back, I hope. I'm hoping for shaking of heads there. As well as institutional aid that can be used, as we talked about under the student side, if we have overages, that those funds can yet again be utilized to go to the students in the event that all of those institutional funds are not consumed by disruptions and information related to Corona from the institutional side. I'm going to stop there, look for affirmation from our four attorneys and your discussion on some of the major things that you're dealing with on the institutional side. Chris?
Well, I think from the institutional side, the challenge is, I think we simply need some more guidance from the department, because from my perspective, and again, I come from an accounting background as well, and I look at when we're looking at costs associated with significant changes to delivery due to coronavirus. Well, there's a lot of things I could put in that bucket. But given the instructions or the directions that we've gotten so far from the department, some of that I think is questionable, and it's not clear. I mean, there's the guidance that the department has put out is saying the things you can't spend it on, and that's pretty clear. You can't spend it on executive compensation. You can't use dividends and stock buybacks. You can't spend it on your athletic facilities and things like that. Okay, it's very clear as far as some of the things that you can't spend it on. And then the idea that you can spend the money for increasing your capacity to deliver online education. If you need to purchase licenses for your students to participate in temporary distance education, things like that. Okay, that's clearly associated with costs that were necessitated to change in delivery due to coronavirus. But then there's things like, well, what if I'm paying rent for a building that I can't use? Is that a cost associated due to the change of change of instruction? Arguably, yeah. I mean, it certainly seems to be a cost of that. But given that the examples that the department gave in the guidance for really getting to the more, what I would say, clear-cut things as far as new equipment, new routers and servers and licenses and software, and training your educators on how to deliver that type of education. So when we get into these middle grounds of, well, I've got these costs, I'm paying for things I can't use because of COVID-19. Is that covered? I think I would want to see some guidance from the department before I say yes on that, because that could be a lot of money and it could be a big risk.
Yeah,
Aaron?
Go ahead, Ed.
I appreciate being called on. By the way, I just want to say I'm so impressed both of these guys have all these law books in the background. I feel like I need to go buy some law books to put behind me when I do my video calls. Maybe put away some of the light fiction. Look,
Aaron, I literally built the bookcases behind me just for this conference. So just did not have them before.
The Lord of the Rings. I got to put that away. I got to get out the 34 CFR.
My Lord of the Rings is up there. You just can't see it.
Like everybody on the call, I'm sure. I mean, I've just been spending all day, every day on calls with clients about these same questions. And I totally agree. There is, as you've mentioned, Tom, there's more guidance coming from the department. And couldn't agree more that we need to see that guidance. I think it will hit on some of the big topics like payroll and lease obligations. But, what I've been struck by is the extraordinary range of proposed potential expenses that clients have thrown out. I mean, there's some that are kind of obvious, but I'm getting all kinds of creative and interesting ideas. And I don't mean inappropriate. I just mean sort of all kinds of interesting ideas that are potentially could be covered, but to the prior point that just aren't yet. It's not clear. What the department has given us, and this is what I'll offer to the conversation, I think institutions, even after we get more guidance, that's still going to be the case, right? We're going to have this general sort of squishy standard at the top, right, for what's a qualifying expense, something that has a reasonable nexus to the disruption on campus to instruction as a result of COVID-19, right? And then you're going to have on the left these items that the department has said clearly qualify, and on the right you're going to have the stuff that clearly does not qualify. And what you're going to have to do is come up with a methodology for deciding and working with your outside counsel, your professional teams, whatever, but figuring out, as you go through all your individual ideas and proposed costs, whether they're on the left and clearly covered, on the right, clearly not okay, or in that middle ground. My recommendation to folks is I think you need to come up with, and we're working with some folks to develop something like this, but, essentially a framework that you commit to paper where you say, these are the categories of expenses that we think we want to cover. And then you offer your rationale, categorically speaking, for why they're covered. If maybe that's a big initiative, or maybe it's just in general, expenses relating to upgrading technology so we could take our students online. And then I think separate from that, you're going to have a spreadsheet or something somewhere that literally has a line item that says peanut butter and jelly sandwiches for the team. And you're going to need to show on that spreadsheet that those peanut butter and jelly sandwiches were provided during the training session when you were teaching your instructors how to instruct online, so that you can tie that line item to the logic that you've got in that other document. But I think it needs to be that level of detail. And I think you're going to have somewhere where you show at least categorically how and why you concluded that these various expenses qualified. And even after we get the guidance from the department, I think there's still going to be a lot of ideas people have and a lot of initiatives and areas that aren't going to fit in any of the really clear, explicit buckets. So you're going to need to be prepared to sort of think through that and document it and be able to show how you did that on the back end.
And just to follow up to Aaron's point on the documentation, and you mentioned this before, but if you're having that meeting with your educators on how to, in the peanut butter and jelly sandwiches and you're allocating that, that training time to payroll associated, that's a cost associated with the changes due to coronavirus. And so under your plan, you're counting that as expenses that fit within, an allowable expense for the institutional piece. if you received proceeds under the Paycheck Protection Program and are using those funds to pay for payroll, you can't. Well, we're counseling folks. You can't double dip. I mean, it's either if those payroll costs are covered under the PPP, you can't then say, oh, I'm going to use money from the grants to pay that payroll again. So you'll have to be documenting at that level as well.
Yeah, I would add to this. Just a couple of thoughts. I agree with what was said by both Aaron and Chris. I mean, again, the certification here says that the costs must have, and this is a quote, a clear nexus of significant changes to the delivery of instruction due to the virus. So, there has to be a really direct line. And I think, again, we don't know exactly where that, what is direct and what's clear, but I think having, as Aaron said, if you're going to cover some, peanut butter and jelly sandwiches for, during your faculty training on how to teach online versus teaching on ground. I mean, is that a clear nexus? It would seem to be, but that's a question. I would note, to Chris's hypothetical about, a building you can't use. I mean, I don't think the intention here was to cover lost opportunity costs or loss of revenues, but really to talk about expenses. Having said that, I'll contradict myself, and this is why we need guidance. The statute on the student side talks about expenses of the student. On the institution side, it says costs of the institution. It doesn't say expenses. Now, I think the department's going to, if I had to predict, it's going to interpret that to mean expenses, actually outlays of money, not losses of money. But I think that's why things like, lost building revenue and other lost revenues, I think for now, most lawyers in the space are saying, don't think you can go there yet, if at all, with these funds. They really should be expenses you've incurred as you make this transition to online or you do other things necessary to still teach in this environment.
Yeah, I think that's right. And I think we do need a lot more guidance on this. I mean, one of the things that you would think would be covered by this would be, again, not changes to the instruction, but your response to COVID, particularly if you're trying to come back online. As some of the states are opening up and schools can start having people come in, well, what about masks, right? What about gloves? What about purchasing? I think Chris and I talked about this the other day. What about if you purchase a kind of a thermal scanner or thermometers to check people as they come in to make sure they don't have a temperature and it's safe to be there? What about deep cleaning? What about what about an atomizer that you fix in your vestibule that spritzes down, some sort of non-toxic disinfectant? I think there are a lot of other issues here that are certainly COVID related, and actually go back to the, if you look at section 18,004, the initial discussion is about the response and preparation for the coronavirus. And then in 18,004A1, or rather, I guess C, right, it talks about use of the funds, and then it talks about some of the other stuff. And so, I mean, I think that there are broader categories. I wouldn't necessarily go spending all the money, though, until we get some of this guidance, just because it's just not safe. I'd rather have the money in my bank account, wait, and I'll allocate it as we get some clarity. Clearly, if you had to get, an enhanced Zoom package with more people that can go online, that would be covered. It clearly, with handing out, Wi-Fi hotspots to students. I mean, those types of things directly related to instruction are there. Again, peanut butter jelly sandwiches, maybe. That's a good maybe. Talk to your auditor on that one. But I think that's I think it will be a broader category, but it's just not necessarily safe to come out. And Tom, I don't know if you noticed, but it pays to sit here and watch that CARES Act website and refresh it like you're like a teenager waiting for a car to come on Friday night, staring out the window. There's new guidance up, right, for the other portions of the grant programs. No new guidance for this, but for the FIPSE portion and for the minority serving institution portion as well. So the department is, still pumping it out.
Cranking it out. Yep.
Hey, Tom, I want to jump in and emphasize something that Dennis just said, which I think is really important. You know, I agree. There was an earlier comment, and we have been counseling clients, particularly with regard to the student loans, emergency grants, you know, that it probably makes sense to disperse most of this money sooner rather than later. There's an obligation in the funding and certification agreement that it be done promptly. You know, the longer you wait, the harder it may be to show that expenses were related to, you know, the coronavirus event, et cetera, et cetera. All of that having been said, there is nothing that requires that you get all of this money out the door the second you get it. And I have been telling clients, and I wholeheartedly agree with Dennis, be patient, take a deep breath. There's more guidance coming from the department. Lots of the big players in higher ed, ACE, NASFA, you know, have been asking questions, and I think it will benefit everyone. You know, spend the time figuring out your protocols, how you're going to document stuff and where, you know, checking out your systems to make sure you can disperse funds, all of those kinds of things. But I don't think there's anything wrong with holding on to these funds, if you're lucky enough to get them in the next couple of weeks, to sitting on them for a couple of weeks and waiting to see what you can get out of the department. Because I think schools that do that are going to benefit from that patience.
Yeah, I absolutely agree with that too. Because I think, and that's something that was interesting when the funds were first made available. It seemed like there was a lot of listserv correspondence of people going on that day to try to get the funds immediately, try to draw them down, and concerned about being able to register and all this. And the response that I had was just, again, same thing: relax. You've got time to do it. It's not like the PPP where it's first come, first served.
That's right.
Funds have been allocated to the schools, so those funds are available. And before you're going to spend them or disperse them or whatever, you know, to use those funds, make sure that you're comfortable and you've got solid counsel and you know that you're using them for the right purposes. Because if that money goes out and it's not for an approved purpose, then you're in a world of hurt because you've made certain certifications and, you know, for both the student funds and the institutional funds, you know, that could cause trouble.
Well,
hold on a second, guys. Let me take the prerogative. I'll get back to you, Jonathan. I promise. Two quick questions, though. Distinction between the student side and the institutional side. There is the case on the student side. Let's stick with the student and let me ask the two questions that I've gotten probably one of these more than any other. But I'll go with the first one that's not that question first. If you're getting the money out to students, there does seem to be some urgency there. And is there not some urgency associated or not? And maybe they're not. I want to hear your answers to this, honestly. What about if you're not getting the money out quick, individuals that could and are in the current payment period or period of enrollment that could graduate before you make your determinations? Is there any concern about what happens there?
Well, this is Aaron.
If you take too much time, I guess let me paraphrase my own self. If you take too much time, there are individuals who could legitimately say they needed help that you didn't give the funds to while you were making your decision, and that may be okay. I'm just curious.
Well,
Aaron,
I'll just offer. First of all, I'm not talking about waiting months. I mean, I'm talking about waiting a couple of weeks. So, you know,
Understood.
just to be clear, and also not to be glib, but most of my clients are not struggling with having too many students graduating too fast right now. Most of them are trying to figure out ways to get students across the finish line. So I think those are obviously valid concerns, and certainly it is possible we've talked about this. If you wait too long, it does become problematic. I'm just talking about waiting a couple of weeks to get your ducks in a row and get as much guidance from the department as possible. Frankly, nobody even has the institutional funds yet, so it's not like we're all sitting on the money. You know, I do think on the student grant side, there are, you know, potentially problems around the optics because the students know the money is out there. I mean, it is public. The secretary keeps issuing press releases that makes it sound like all the schools have the money, which is not necessarily helpful. So I do think there will be those who start to ask, you know, where are the funds? But I still am preaching patience, at least for a couple of weeks.
Good fellow, well met, Aaron. I agree, but some of the schools are starting to get some of the monies, and some of the schools are starting to ask some of those questions because with continuous enrollments and rolling enrollments and rolling graduations as well. I agree with you. There's a lot of students and institutions that are frustrated with the inability to complete their education, but there are others that are making their way to the end of the system, and schools are asking some of those questions as well.
Yeah,
Dennis,
Tom, yeah, I mean, I think I think about the specific question about the graduation. I mean, the way I see it, those students are still eligible for that money, right? This is expenses due to disruptions in education due to coronavirus. And so let's take a likely real world example. We've moved online. The student does not have or has a computer that's not apt for the purpose and had to purchase that computer. That she had to purchase that computer does not invalidate her requirement to get that money, right? That she had to pay $500, $600, $700, $800, whatever it is for the computer, or had to ask, her parents for that money so she could continue her education. She's still entitled to the money as well. Whatever the school's giving out, she's entitled to that. So the fact that she has graduated does not remove that need. She had a cost associated with the disruption due to coronavirus, and she's entitled to the reimbursement, again, to whatever determination the school makes as to how much each person gets.
You're getting to one of the questions that we had. Go ahead, Jonathan.
Well, I was going to add on the institutional side, I think depending on where you are located and depending on what the prognosis is for reopening, that time frame may be longer in terms of waiting to figure out how you're going to spend the money. If you're an institution in a major metropolitan area, let's just say the New York City tri-state area, you might have more institutional costs than over a longer period of time due to disruption than somebody who's not in New York City tri-state, right? And so I think it's really important, in addition to waiting for additional guidance on the institutional funds, also wait to see what is the reopening going to look like, depending upon the stay-at-home orders, depending on what your density, permissiveness on density is going to be. Because you might, if you're more in an urban setting, you might have to reduce density in your classrooms, which might mean in 6 months you're retrofitting certain classrooms for courses that are better taught online than on ground and online. So I think you have to take all of that into consideration. It's not a one-size-fits-all approach. And in terms of, your plans for the institutional money, take into account, obviously, I don't want to not say it, even though it's sort of an obvious point, really think about how your operations relate to what's going on in your geography for relaxing the stay-at-home and lockdown orders over the next 6 to 9 months, which it may be that way in some locations.
So again, patience as well. All right, now I'm going to take the flip side, and Aaron, go directly to what you talked about, which I yet again concur. I'm hearing many institutions that on behalf of their students either had individuals on LOA or had to put their students on LOA because of clinicals, internships, or externships that were unable or incapable of being continued or provided, and therefore LOAs are necessitated. Are those students eligible for, and should schools be giving them access to the student portion of those funds? A lot of institutions have asked questions, and there is no, at least I'm not aware of, there's no clear guidance on LOA in that regard, because it's part of what we expect to come with some of the additional guidance yet to follow. But it's a question I've gotten, if I've gotten it once, I truly have gotten it over 100 times.
Yeah, I'll take a stab at this. I mean, again, caveat, guidance is coming and you should wait for that. But, my view is the department, when all this hit, created flexibility, and intentionally made it easier to put folks on LOAs and to give students that option. So first of all, I don't see anything in the statute that would prohibit an active student who's on a leave of absence from receiving emergency grants. Second, the department has created that flexibility to allow students and schools to go that route. Third, I don't know why being on an LOA would necessarily mean an individual didn't have qualifying expenses. I mean, it would seem to me a little odd if the department landed in a place where students on LOAs wouldn't be eligible. Also, I mean, they were pretty careful about excluding non-Title IV, non-immigrants, most non-immigrants, and undocumented students. It seems like they could have been clear about excluding LOAs if they had wanted to do that. My gut is that, you can include them in your pool. But again, I know there is question around that, and we'll see what the department has to say. Hopefully they'll make it very explicit. If you're concerned and you want to go ahead and start moving out grants, include them in your pool, but hold back the funds until you get more clarity.
I'm going to switch now to one of the other questions that the media has spent a great deal of time on this week. It is a section 18006. Dennis, you're smiling. You were quoted in recent media with regard to the language that talks about for all of the education stabilization funds, and it does speak to whether it's the states, the LEAs, or institutions of higher education. It says, to the extent practicable, institutions should work to keep all of their employees and the like. It's made a great deal of headway in terms of discussion here in Washington and certainly in the media around what that means. Would the three of you or the four of you like to share a little bit about that before we turn it over to, for the last 20 or so minutes, to questions from our community?
Sure, I'll give it a start here. So, I mean, first, so everyone knows, this is a statutory issue. That the article, I think, suggested that this was the Department of Education standard. While quoted in the letter that Secretary DeVos put out there, and I believe in the certification, this is a statutory standard. That being said, I firmly believe the department is going to be reasonable on this. One, I think the department has been reasonable on a lot of things that they don't necessarily get credit for, including rulemaking, that they've been very thoughtful in trying to take everybody else's views. And I think they don't want to see this be the rule that prevents people from taking money that they need to get out to students and to help institutions making dramatic changes in their program. So I think there's a rule of reason that applies to this. I also, as I mentioned in the article, there are the CARES Act. Everyone focuses on the money and because it's money, but there are other parts of the CARES Act. If a student does not complete their education this term due to coronavirus, well, the loan is forgiven for this term. The Pell Grant eligibility is restored. I mean, these are all wonderful benefits, but they're expensive. It is far more cost effective for the department to allow an institution to give a $400 or $500 grant to a student so they can continue taking their education than it is to forgive all those amounts with the loans and the grants. And as a result, it just defies logic to me. The department is going to be overly strenuous in what it means to continue to pay your employees and contractors to the greatest extent practicable. I think there's got to be a reasonable standard there. Again, if you're firing, half of your workforce, I don't know that that's the greatest extent practical. But if you've got one division within your school that is used to taking in-person appointments, we'll say, and the receptionist and a few other people that are there that work that front desk, they get furloughed, that seems to be a fairly reasonable thing to do. And you could certainly make that argument. Now, I'll subject that to everyone else's criticism.
No, I mean, I'll go. I think I generally agree with you, Des. I guess I would say, I'm less concerned about the department or even the Department of Justice than I am because, the certification gives rise to false claims, whistleblower possibilities, right? And I don't know who that would be in a couple of years. I agree with you. I mean, I think the department will be reasonable. And where in the CARES Act, looking again at the whole CARES Act, where the Congress wanted a mandatory prescriptive requirement, it's very clear. And here Congress said, to the extent practicable. That, to me, that has to mean something, that distinction. But they knew it wasn't necessarily going to be a bright line, strict liability. On the other hand, if I'm thinking about defending a decision down the road to furlough or terminate someone while receiving these funds, again, as I said earlier, I think documentation as to the basis for that is really critical. whether it was a pre-planned action before this all hit, have that documented. I would say for positions that are not thought of as being sort of doable online, maybe you make some reasonable effort to move people, whether it be career services or placement, see if you can come up with something to make some of those people or have some of those people work online in a virtual context. And if it doesn't work, then you can say, well, we tried. But I think there is, I mean, I don't want to be, doom and gloom, but I think there is the possibility, because there's already, a lot of plaintiffs firms circulating the higher education space around what's been done in this time. This will be one of those things that those firms go after. And so I think being able to document that you did do everything reasonably possible to keep individuals employed and paid is something to think about. Doesn't mean you have to be, 100%. But I certainly would be very cautious about any significant changes, or just saying, well, that person can't do their job online or can't do their job remotely at all before you terminate them. Maybe they can do something else, or maybe the job could be jiggered to work in a virtual setting, perhaps. And I think having that reasonable showing of effort will be useful down the line.
I'm going to start with some of the questions with and a kind of a lightning round. And hopefully you guys can stick around for a few minutes after if we go a few minutes beyond. Let me get through one or two slides very quickly, just because that's all the time it's going to take. With regard to the new policy guidance and on the true policy guidance, as we see things continue to come out, conversations I've had with Department of Ed officials that are responsible for what I'm calling the true policy guidance, SAP, LOAs, all of the issues surrounding financial responsibility requirements, as well as the various other portions that weren't necessarily addressed, but they said were coming attractions in the March guidance, quote, are ready for prime time and should be coming soon. Soon, as we know with the department, is a relative term, but as we've all discussed multiple times on this call, they do seem to be churning out information at a pretty steady pace. So I wouldn't be surprised if we see it yet before the end of this week, or if passed as prologue, maybe by no later than next Tuesday, seeing as how on the two previous Tuesdays prior to this Tuesday were when a number of significant documents and announcements were made by the department. So just know that we all are waiting for a lot of this additional guidance. Certainly, we all have our own inroads to the department and elsewhere, and are certainly all hitting that button, just like they're waiting for the response from a prom date or anything else to see what comes out of the department's website. Shifting to the Q&A from our community, if a prior employee is, and this is with regard to the PPP, if a prior employee is currently not able to work, can another employee pick up the additional hours of the individual to be used for compliance of the PPP spending? Employee is no longer available that worked a specific number of hours. Can we put somebody else in that position? I think the answer in general is yes, because what they're looking for, and you're allowed to bring back furlough and other individuals under the PPP, what they're looking for is a maintenance of general economic stability. And obviously, if another individual is no longer there, if you've got somebody else in the position, that seems to be hopefully okay. But any comments?
With the PPP program, I mean, the question I think really what it gets to is, of those proceeds, there's the loan forgiveness piece of the PPP program, and so that's based on allowable expenses and a comparison of head count when you get into, what was your past, level of employment versus, okay, what's your level of employment now, to see how much of those eligible costs are going to be forgiven. So I think, if you're having somebody else do extra work and you're paying them more, now then that also gets into, well, how much are you paying them? Because you only can count only $100,000 is the cap on individual compensation as far as an eligible cost. So those are all the things that are going to come into play. But certainly, I mean, when you're comparing your head count today versus your head count from a year ago,
you're going to do. It's not going to be the exact same people. There's going to be people in and out, and I think the intent there is to make sure that you're keeping your the same relative number of people employed. I think that's the whole goal.
If we provide students disbursements for the second tranche with the second tranche of funds, meaning the institutional portion, do they need to be Title IV eligible, or can we provide or are we provided more leeway to give to students like DACA students?
I don't think there's any dispute here. The department's very clear that if you're going to make those emergency student grants out of the institutional, actually there's no ambiguity. If you're going to make those grants out of the institutional tranche, they have to meet all the criteria that are in place for the student tranche, which means Title IV eligible expenses related to coronavirus disruption of their program, et cetera, et cetera. So I don't think.
But Jonathan, what if you're using the 49% from the institutional side? That's what they're asking. If you're using the apportionment from your institutional funds, the overage, I believe that question number 5 specifically says you have to use it for the same eligible students that were the eligible students under the student side.
That's what I'm saying. They have to meet all the criteria on the student side. So you have to treat it all the same.
So,
Tom,
go ahead.
Yeah, Tom, this is Aaron. I mean, I'll just add, I've had a number of clients who have suggested using the institutional share for various types of sort of student grant concepts. And I would just caution folks, the department clearly contemplated that if you're going to use some of the institutional share to make grants to students, that you would have to administer that in the same way that the emergency student grants are administered. And I think if you try to come up with some sort of grant program and say, hey, this is how the institutional share, we're giving grants to students, but it's not emergency grants, we're providing these for XYZ, I think that could be a flag for auditors down the road, because it's still a program pursuant to which you're giving grants of cash to students. And if I'm the department, I'm going to say, well, wait a minute, were you just trying to get around the restrictions that govern the emergency grant program? So I would just be real careful. Yeah.
I agree.
It's interesting though, because the department limiting it to Title IV eligible students, and I do wonder if they tried. They thought they were in a very tight legal box and tried to be as expansive as they could, because it seems as though the department hasn't said this, but I imagine that the 1996 welfare law that precludes the provision of cash federal benefits going to non-citizens or non-documented aliens. There is an exception in that law, though, for non-cash benefits. I mean, I do wonder. I mean, I don't know how the department reacted, but let's say you just bought computers and said, "Here, take a computer," or you bought hotspots that everybody, you want to come, you can come take your hotspot, or mail you the non-cash in-kind item. That may be a way to provide some marginal help to folks in a way that's agnostic. But and I agree with Aaron. I think, if you're giving cash to people, I don't know that there's a real basis to do so, and kind of being too cute by half with saying it's institutional funds or some of these other machinations probably doesn't pass the smell test.
A similar line of questioning that, again, I think can an otherwise eligible student who is enrolled in a degree program that is currently not approved for Title IV receive funds from either the first or the second portion of the funds? So if the program is not Title IV eligible, what say all of you in terms of an individual who meets the Title IV eligibility requirements, but the program is not Title IV eligible, can they utilize those funds?
I mean, doesn't Section 484 say you've got to be enrolled in an eligible program?
That would be my interpretation, but I'm asking you the question. I think that's the answer.
I think that has to be the assumed answer until we have anything to the contrary.
Agreed. What if a student wants to use their student institutional emergency grant assistance to pay tuition?
Well, this is Aaron. I like most of the other folks suspect we've all received that question a bunch of times. And, my view, I'm interested in what Chris DeLuca has to say, but my view is you need to have an accounting trail that shows that you put that cash out the door and into the hand of the student. And, if the student decides to come back to school the next day and, I really want to pay off some of my outstanding balance, I don't think there's anything that precludes you from accepting those funds, but I would just be real careful about any appearance that you were applying that money to the outstanding balance, or that I don't like the opt-in, opt-out, all those kinds of things. I think the cash has got to go out the door. The check needs to be cashed and in the student's pocket before they come back and apply it to an outstanding balance.
Well, and out the door to a student for an eligible student expense, which is not tuition and fees, right? But if they decide to use it for tuition and fees and the audit trail is clear you gave it to them for something else. But again, I think Chris, from the CPA side, I'd be curious what your thoughts are.
Well, I agree with both of you, and I think in addition to making sure that the money goes out to the students, cash, the funds are received, that they receive a however you're distributing it, that it goes out to the student. And if they turn around and write you a check for tuition, but before they're going to write you that check for tuition, you're going to have some sort of attestation from the student. You're going to have some documentation, whatever it says you say under your plan, as far as making sure that the student agrees that, here's the allowable expenses, right? So, this is what the funds can be used for. And so you're going to have that attestation from the student. But then if a week later the student decides they want to pay down their balance that's owed to the school, there's nothing to stop them from doing that. But and then that also gets into making sure you're communicating to students. You don't want there to be any implication that you're telling students, hey, go cash this check and then pay us, what you owe us. You don't want there to be any any hint that you're engaging in that type of instructions or dialogue with the students, that you're telling the students this is what it's for. If they on their own decide that they're going to turn around and write you a separate check, then I don't think there's anything to stop them from doing that. At some point they're going to have to cut your checks anyway. They're going to have to pay their balances at some point.
And the separate check, Chris, the separate check's an important point too. That goes back to what Jonathan said. You don't want them just signing over, their check to you. It really needs to be a separate check.
Absolutely. Yeah.
Another, I think, pretty straightforward question. Are graduate students eligible for the HERF funds? Yes is the answer, correct? Are we all in agreement?
Yes.
Yes.
Yay. We are a non-term based institution and classes scheduled to begin in May. New students. Could those funds be reserved for new students starting after May 13th date? Yes is the answer, because they fall between the March and the June 1st time for the application. Correct, gentlemen?
So when I've had this conversation with clients, I think it looks to this. You go back to, are the students who are enrolling May 13th, do they have expenses related to the change in the delivery of instruction? And so, and that's going to be dependent on the program. You have to look at it. I think you have to look at it on a case by case basis. If they enrolled fully knowing that it's going to be online, then do they have any expenses related to that? I think you've got to look at the program and the expectations. I know, working with one school that had a class that started in April, it was after but it was planned to be, everybody had enrolled and they had engaged in student signing enrollment agreements before the governor shut down the state, right? And so there was every expectation for those students that they were going to be enrolled in traditional brick and mortar, but now they're not, and so they've got expenses related to that, even though it occurred after, they were enrolled after the shutdown. When you're getting into May, June, July classes, again, I think there has to be that connection that those students are incurring some costs or something related to the change in delivery of instruction.
Right, but the April 8th guidance specifically said that the department was extending the eligibility to June 1st.
Well, that's for the relief within, at least my read of it. I'll be curious. That's for the relief in that guidance on the regulatory provisions or for terms that begin on or before June 1st. I think in terms of my view is the same as Chris's in terms of the CARES Act funding. That conceptually, I think about it this way: these emergency student grants are for things that would be generally considered in the cost of attendance in an EFC calculation. But they weren't because those calculations were done before the pandemic hit. And so I think, if a student is enrolling for the first time or has a program starting for which the EFC and the COA is being calculated prospectively, I think to me it should be handled through that process, the normal Title IV process, because it wasn't a program or cost or planned budgets that were hit by the coronavirus pandemic. I think it's a very factually specific inquiry. But I think this is driven more by the statute and by the funding criteria than by the regulatory relief in the earlier guidance. But that's my view. It sounds like there may be some disagreement.
Well, I mean, what happens if someone tops out their aid, right? If they don't get enough aid to cover the increased cost of attendance there, because they max out on their Stafford loan or what have you.
Well, that would be that may be a situation where it would be eligible. I mean, I think it's something we should probably keep the department to.
Point.
Yeah.
A lot of these are repeats, and we are at time. So as I have done before, I'm going to say that we unfortunately can't get to all these questions, but I will print them out and share them amongst in between the team and try and get us answers. Candidly, a lot of what I'm seeing that I didn't ask are ones that I know we still don't have answers to based on the lack of guidance on things like R2T4 and others. It's not that I'm not reviewing the questions. It's just simply until we see more from the department, I don't think that there's any information that we have to share. With that, the one last thing I would like to do is, on behalf of C-SPEN, once again, thank all four of our presenters for sharing time with us today. I've learned a lot, as I expected I would, and very much appreciate all of you taking the time to share with us your general information. Again, not to be utilized, if I said it enough times, guys, for the basis of your own decision making, but in order to inform your further discussions with your council, your third-party servicers, and the other individuals that are decision makers within each of your own institutions. One of the things I would like to say in closing, along with thanking everybody for today's presentation, is I'm proud to announce that on next Tuesday, we will be having a conversation specifically on clinicals, internships, and externships. And we will have as our special guest for that presentation, one Diane Hour-Jones, the Deputy Undersecretary for the Department of Education, who has agreed to share some time with our community on that call. I'm pretty proud to have her take the opportunity and take time out of her very, very busy schedule to agree to come and share with us. In the conversations I've had with her leading up to her agreement to participate, please realize she doesn't have all the answers to all the questions either. A number of the issues that obviously we will be dealing with next week deal with other members of the triad standards and guidance as well. So it is things that are outside of the purview or the control of the department in terms of what accreditors and states have in terms of their guidance and requirements and the like. But she has agreed to participate. I also have requested, if possible, a number of the accreditors to see if they can join us on the call. I already have India Tibbs, because there is so much focused on allied health, but not exclusively, that has agreed to participate. I'm hoping for some of the other accreditors to come on board. So look for that in announcements of the upcoming webinar for next Tuesday in the days ahead. And last but certainly not least, next Thursday, we will be having another C-SPEN webinar where we will focus on an institution that has remained open and done a number of things throughout the pandemic and the reaction of their students as they've continued to be both on campus as well as supporting individuals away from campus. what that looked like over the past 14 weeks, and candidly, a look for the next 13 or 14 weeks leading into CSPEN's annual conference, which we will also be promoting later this week. Fingers crossed, we are still looking to be in St. Louis in August, and looking and hoping for many of you to be with us. I know Aaron will be there. It's his backyard, but hopefully many of the others will be there as well.
And, it's always 72
again,
degrees every August in St. Louis. Every day is 72 degrees. I just want to make sure.
Well, see, there you go. Perfect weather. But again,
they paint the orange as a rainbow.
Sincerely, Aaron,
Right.
Chris, Jonathan, and last but not least, Dennis, thank you very, very much for your time. Thank you very, very much for all you do for our community. It is yeoman's work, and you all do it very professionally and very well. And thank you so much for sticking with the mantra that we have here at CSPEN, which is the desire to share and communicate with the community for the betterment of all. So with that, thank you for today's webinar. We look and hope forward to seeing many of you again next Tuesday and Thursday. Have a great weekend. Stay safe, stay well, and do what you're told. Thanks. Bye.
Thank you, Tom.
Thank you.
Thank you.
Bye, all.